Hi all, welcome to today's colloquium, the Constitution and the Politics of Citizenship. We've got three distinguished panelists. I will be introducing them to you soon enough. Chandan, who organizes the colloquiums, thought that I should give a context to the conversation that's happening today. So I thought I'll do that in terms of, I guess, two questions addressed to the panelists as well as a comment. The CA, the anti-CA movement, it is a movement by now, I guess. It's organized around two anchoring points. One is around the question of nationalism, the other is around constitutionalism, right? So let me say a few things about constitutionalism first. How frail is the invocation of constitution or constitutional values, or however you put it, constitutional morality and whatnot, in these movements? Is this gesture a tokenist one? Is it about some version of political expediency? Or, how else do we see it? Contrarily, are we witnessing a sort of a version of deepening of these values in India? Is that the case? In which case, it would amount to what, many continental philosophers would call, an event. An event is a moment which does not transparently reveal itself. It has a certain semiotic density in itself, which needs to be peeled off as we go along. Are we witnessing some such moment? Right? I say that also because, as recently as yesterday or day before, Ranadeep Samadar, came up with this piece in Wire, where he called it insurgent constitutionalism, right? Which is to say that a certain claim to constitutionalism, which in some ways speaks to the question of justice beyond any judgment, so to speak, right? So I would like to hear as to what the panelists think about that. The second is the question around nationalism. In any socio-political milieu, there's a regime of the sayable and the unsayable, right? In the moment that we live in, given that nationalism in some ways is one of the meta signifiers in the contemporary moment, in India especially, there's a way in which you cannot speak against the nation anymore. 20 years ago, when I was in grad school, it was very much possible. As a matter of fact, 6-7 years ago, when I started teaching a course on nationalism here, which I still teach, it was possible to actually be, to rampantly, critique the very category of the nation itself. However, that doesn't seem to be possible anymore. Right? As a matter of fact, Rohit Vemula's mother, along with other dadis of the Shaheen Bagh movement on 26th January on the Republic Day, began their speech by invoking the nation. Right? One can understand as to why they did that. They did that because they wanted to wrest the discourse of the nation from the right. And yet the point I'm trying to make is that there is a way in which you cannot invoke Tagore's, trenchant, almost an excoriating critique of the nation anymore, right? Can we get past that moment? Can Tagore be invoked? Can Gandhi be invoked? The third comment, quickly, I'll be trying to be brief. In the current form that CA exists, is there anything that is ethically sustainable there? Can it be, can we make a case for it? I say that also because a very close friend, an esteemed colleague who I've known for 6-7 years by now, thought that there is something about, there is a plea which inheres the CAA, which in some ways is about maintaining a fidelity to the suffering of those who are suffering in these three countries, and especially Hindus, that in some way needs to be addressed. And there's an urgency around it, right? Given that we're already way too late, right? Now the question is that, that plea, how do we read that plea? How do we understand that? If one were to, she already knows that I disagree with her, but I'm trying to understand where she's coming from. Can we think through a sort of a singular notion of justice, or a justice which is just to the singular? And if so, what would that look like, and does it make sense? All right. Okay, let me not say more. I hope some of these issues and questions will be addressed. Our first speaker today is Malvika Prasad. She's an advocate and doctoral fellow at Nrc University of Law. Her goal is to understand and help bridge the gulf between the Constitution of India and the Constitution of India. Towards this, she studies constitutional claims made by and between actors between the court systems. She also teaches law and science at the Indian Institute of Science, Bangalore. Previously, she has worked on both sides of the bar, clerking for a judge of the Delhi High Court and as an advocate of the Supreme Court of India and other courts. She holds degrees from the Nrc University of Law and University of Michigan Law School as a Grotius Fellow. Malvika, please. Everyone will be speaking for about 15 minutes, and in about 50 odd minutes, we'll open the floor for conversation.
Good afternoon. Thank you to the university for offering us this forum. I'm just going to briefly walk us through what it is that the CAA 2019 does. But before that, I'll try to supply some context on what the citizenship law looked like in India in the run-up to this amendment. So the citizenship law in India has three distinct phases, and the study of the CAA really needs to reckon with the evolution that citizenship law takes in India over these three phases. So we draft the constitution, the rest of the constitution comes into force on the 26th of January 1950, but citizenship provisions come into force on the 26th of November 1949. And the context that the constitution speaks to is that of partition. So the framers of the constitution have very almost bitter debates in the assembly about the ways in which they want to make citizenship available in the context of the migration that partition has caused between India and Pakistan. But the important thing to note at the time is we're only talking about Western Pakistan, and migration is merely the social phenomenon on the basis of which we will decide who will be a citizen. So 55 is when we enact the citizenship law, and the reason that we have to enact a citizenship law in 1955 is that the constitution only speaks to the question of citizenship for migrants between Pakistan and India and for those who are already within Indian soil as of the date of the entry into force of the constitution. The constitution expressly says future parliaments, in Article 11, future parliaments will have an unbridled power to enact a law to state the ways in which citizenship can be acquired and terminated in India and every other incidental matter. The way in which Article 11 is phrased looks ostensibly like it's an unfettered power, but there are good arguments to be made that it isn't. But without getting into that, maybe we can talk about it after Alok's presentation. 1955 is when we enact a citizenship law in Parliament, and this law lays down citizenship in the acquisition of citizenship over four different paradigms. One is birth, one is registration, the other is naturalization, and the other is descent. Birth, as of 1955, is simple. It's the jus soli regime. You need to be born in the soil in order to be a citizen of the country. In 1986 is when we see a big change in this regime. It's not just enough to be born in the soil of India. You have to also have one parent who is an Indian citizen, which is to say, as of 1986, not only do you have to show that you were born in the soil of India, you also have to show that your parent who was born prior to 86 was also born within the soil of India and meet the conditions either laid down in the Constitution's provision or in the Act itself. What determines this amendment? There are a few sort of movements, migratory movements, so to speak, both from Sri Lanka and from Assam at the time, that sort of frame this context. Arun's actually written about this in a really nice descriptive long piece. So 1986, this amendment comes into being, and apart from the changes on the birth regime, there's also some changes made to how citizenship can be acquired by registration, but I won't speak to that at this moment. So 86 to 2003, if you're a child born in India, you have to show not only that you were born in India, but also that your parent is one of your parents is an Indian citizen. Now 2003 is a second sort of big change in citizenship law, and this change is that not only should you show, if you're a child born in India after 2003, not only should you show that you were born in Indian soil and that one of your parents is an Indian citizen, but that the other parent is not an illegal migrant. This concept of the illegal migrant really makes its big entry into the citizenship law in 2003, even though the concern with illegal migration, so to speak, is something that we've seen in 1986 when the first set of amendments come in. So if you were born in India post-2003, which is, keep in mind, the bunch of children in India who will only attain majority in 2021, if you were born in India after 2003, then you have to show that one of your parents is a citizen by the rules already laid down up until the 1986 amendment, and that the other is not an illegal migrant. So I'm going to talk a little bit about how this concept of citizen becomes framed in opposition to the illegal migrant. Right? So an illegal migrant in Indian citizenship law is a foreigner who is in India either without a valid visa or with a valid visa, but with the valid visa having expired its period of validity. A foreigner is not defined under the Indian Citizenship Act, but the illegal migrant is defined under the Indian Citizenship Act. So where do we look to find the definition of a foreigner? We look at the Foreigners Act, which you wouldn't think to otherwise look at because the Foreigners Act governs immigration, and immigration necessarily is not something that concerns us as citizens, but this is where we start sort of creating the two sides of the coin, citizenship and foreigner. So Foreigners Act defines the foreigner as any person who is not a citizen of India. The other things that the Foreigners Act speaks to are how can a foreigner enter into India legally, if you are not someone entering into India legally, what happens to you at the border, so on and so forth. But for our present context, in 2003, we now have to show not only that you were born in, one of us is born in India, that one of our parents is an Indian citizen, but the other is not an illegal migrant, that is, not a foreigner who is in India due to an invalid visa or a visa that never existed to begin with. Cut forward to 2019, so the context of the 2003 amendment is this. India has just walked away from the war in Kargil, or the Kargil war has ended, and the worry for the Vajpayee government of the time is that there is this uncontrollable infiltrator problem from the West Pakistan, from the western border to Pakistan, and we need to be able to ensure that all the people who are being treated as citizens are actually citizens of this country. So a bunch of other amendments come in 2003 along with this creation of the illegal migrant. And some of them are the rules that bring into existence the need to compulsorily register yourself in the National Register of Citizens, but that's a topic for another day. So 2019, and we now have an amendment that builds out the concept of a citizen in opposition to ostensibly the concept of a refugee. And over the course of the next 10 minutes, I'll try to unpack a little bit of whether that's really true. So in 2019, the amendment that comes into being says that the definition of illegal migrants that has existed so far will now exclude this group of people. Why does the amendment have to begin with excluding a certain category of people from the concept of illegal migrants? The reason is that in 2003, when we brought into existence the illegal migrant as a concept in citizenship law, you couldn't apply for citizenship under the Indian Citizenship Act unless you could show you're not an illegal migrant. So if you want to apply as by way of registration, let's say that you have married an Indian citizen and therefore you want to apply for citizenship by registration, you have to necessarily show that your status as a foreigner in India is legal and therefore you're entitled to claim citizenship by registration. Likewise, for every other method of claiming citizenship as of 2003, the first barrier is you have to show you're not an illegal migrant. Which is why the 2019 Act opens with clarifying that this category of people that India now wants to provide shelter to will not be illegal migrants. What is that category of people? They need to meet 4 criteria. First, persons have to be from either the Hindu, Christian, Sikh, Buddhist, Jain or Parsi communities. They have to have come into India from either Pakistan, Afghanistan or Bangladesh. They have to have been in India since before the 31st of December 2014. And they have to also be exempted under the Foreigners and the Passports Act. So the Foreigners Act is a thing that now becomes intertwined with citizenship once again, first in 2003 and now for a second time here. The validity of these conditions are something that I think will be covered by Alok in his presentation, so I won't go into them, but there's just 2 things I want to stress. One is that this is an act that speaks to people who are already in India. Then we're not saying tomorrow onwards everyone who is persecuted, who is entering India from Pakistan, Afghanistan and Bangladesh will be given citizenship. We're saying people who are already in India, so we're saying people who are already in India as of 2014 December will now be divided into 2 categories based on the religious identity they claim to be from. And some of them will be given the benefit of citizenship and others will not. So this is fundamentally different than, say, the prospective application of a reservation law where you say, okay, those of you who are applying to my educational institution, some of you I will consider, along with the way you do in the entrance exam, also social disadvantage. This is fundamentally different than that. This is like saying APU has already admitted 1,000 students, somehow or the other, we don't know how, and now that these students are inside, the APU administration says, I will teach only 300 of you because I like your religious identity and the rest of you are not my concern. And the second thing I want to emphasize is the exemption under the Foreigners and Passport Act. So we know from popular media and the debates in Parliament when this act came into being that this act ostensibly is attempting to protect refugees. But the 4 conditions in the act do not mention refugees at all. If you look for religious persecution as a term in the Act, the only place you'll find it is in the statements of objects and reasons. Now, the statements of objects and reasons are not an enforceable part of the law. It's what judges and lawyers look to understand the context and the mischief, so to speak, that the law was being passed to fix. In the Act itself, in its operational binding provisions, there is no mention of religious persecution, but there is this condition that this category of people must also have been exempted under the Foreigners and the Passports Act. The Foreigners Act, I told you, determines how foreigners may legally enter India. The Passport Entry into India Act 1920 determines the sort of basic document you need to have to cross the borders, which is the passport. The exemption power under both the Foreigners and the Passports Act is a power that the law, which is a legislation passed by Parliament, or in the case of the 1920 Act, passed by the legislature prior to the Parliament under the Government of India Acts. So this legislation confers a power of exemption on the government under both of these laws. And this is an important thing to reckon with because the government is an executive body and doesn't answer to us in the direct and immediate way that we believe our legislators are accountable to us. So the government has this exemption power, and in 2015, the government enacts a notification which says that the same category of people, Hindus, Christians, Sikhs, Buddhists, Jains and Parsis, who have entered India from Pakistan, Afghanistan or Bangladesh prior to the 31st of December 2014 shall be exempt from those 2 laws, the Foreigners and the Passports Act, which is to say they're exempt from the rigors of immigration law as a whole if they were fleeing religious persecution in their home countries. So the first indication that we need to find communities that were fleeing religious persecution is under these notifications under the Passport and the Foreigners Act. The citizenship law ostensibly attempts to protect refugees, but we now know that the verification of whether these people will be refugees happens under a different regime, the Passport and the Foreigners Act regime. This law then goes on to grant a path to citizenship for these people who have been exempted from the definition of illegal migrants, because remember, you can only be a citizen if you're not an illegal migrant. And then it also makes an exemption for persons living, it doesn't even say persons, it says there's an exemption from this provision to all regions governed under the inner line permit regime and the 6th schedule regime. The inner line permit regime and the 6th schedule regime broadly refer to the governance models that we have committed to for tribal areas in the northeast. So the elephant in the room is really, is this a refugee law? And in 2003, the Ministry of Home Affairs answers in the 0 hour in Parliament categorically that India does not give asylum status to refugees from any country. And this continues to be our position, because with Tibetan refugees, we've never recognized them as refugees. With Sri Lankan Tamils, we never recognized them as refugees. Or rather, Tamils returning to India from Sri Lanka, we never recognized them as refugees. And this consistency in position is actually admirable. We've never had a refugee status determination offered to anybody fleeing conditions of persecution in India, barring the few circumstances governed by the UNHCR's existence in India. Now, the UNHCR speaks to a special set of circumstances. They exist in India at the behest of the government by way of a memorandum. So that's not really a legally binding obligation India has taken onto itself. The only legally binding obligation that India does have is the obligation to refugees imposed in international law, which is the principle of non-refoulement. Principle of non-refoulement is that if somebody is fleeing persecution and is at your border seeking asylum, you cannot send them back to their conditions of persecution. But this is a position we have constantly distanced ourselves from. We have said we do not offer asylum to anyone from any country. If the CAA was a refugee law, then okay, maybe the government would have been valid in wanting to prefer some communities to grant citizenship. I'm not conceding that on principle because I don't believe the government is valid, but let's assume for a moment in favor of government that it is okay to grant citizenship to some persecuted communities. At the very least, the refugee protection law would also have to state that everybody else who doesn't get this protection under the CAA will still be protected under the principle of non-refoulement. Which is to say, everybody else who is not considered a beneficiary of the CAA will still undergo refugee status determination, and they will still have a chance to show why they deserve asylum. And then India will grant asylum on the basis of these 3 or 4 procedures, right? So some of the ways you can grant asylum, you can just declare someone refugee and say you're welcome to stay in India with this refugee ID card. Or you can give them some kind of short-term work visa. You can give them a long-term work visa. There are any number of ways in which India could have figured out the manner in which we would have granted asylum. But the distinctive thing about this law is that there is no statement on what happens to refugees other than these groups that will receive the benefit of the law. So to close, what would a refugee law actually look like? It would be prospective. It would not govern people who are already in India. It would have a determining principle, which is something similar to you must have faced persecution of this variety in your home country, neutrally applicable. And finally, the first barrier that that person claiming asylum would have to cross would have to be status determination, because that's where you prove before some authority that you suffered persecution and you cannot be sent back home. All of these 3 elements are missing in the CAA, and I think they are causes for concern. Alok will now lift off to speak to exactly how those concerns are articulated in the constitutional framework. Thank you very much.
Thanks, Malvika. Quickly, let me just introduce the next speaker. Alok Prasanna Kumar is a senior resident fellow and team lead with the Karnataka. His area of research includes judicial reform, constitutional law, urban development, and law and technology. He graduated with a BA and LLB honors from Nrc University, Hyderabad in 2008 and obtained the BCL from University of Oxford in 2009.
Good afternoon, everyone, and thank you for inviting me to speak here on the Citizenship Amendment Act and well, not so much the NRC, but I'll focus to talk a little bit about it right at the end. Malvika has already introduced the law to you, so I'm not going to spend too much time on it. I'll jump straight into the things that she said, what this law essentially does. What this law does is to give illegal migrants who tick 4 boxes an opportunity to become citizens. As we've clarified so far, this is not a refugee law. It's not as if it applies to all kinds of refugees coming in from all countries and deals with their refugee status. And of course, it's not prospective. It applies only to a very limited number of people. The number that I have seen is about 31,000 or so, 31,331 or so. That's the number that the Ministry of Home Affairs has told before the standing committee which examined this law, to say that these are the people who are governed by this law. What does that mean? These are the exact number of people who meet all 4 requirements that Malvika listed out, that you have to belong to one of 6 religions, that you are from one of 3 countries, that you have come to India before 31st of December 2015, and that you have received, 2014, and that you have received an exemption under the 2 laws that Malvika mentioned. It is not as if that these 31,331 will automatically receive citizenship. They have to apply for citizenship. They have to apply in the form provided for, mention the details that are required, and hope that the government gives them citizenship. So it's not an automatic process. It's for these 31,000 people, and if they clear all the hurdles set forth by the government, they will become citizens. There are 2 hurdles that they're going to have a lot of difficulty clearing. One is the fact that the law nowhere says, how do you determine if someone is a Hindu, Sikh, Parsi, Christian, Jain, or Buddhist? In common parlance, we all know what this means, but the law has no clear definition. When I say the law, I just don't mean the Citizenship Amendment Act. I'm saying the corpus of Indian law is not going to be able to give you a clear and identifiable definition of any of these religions. The only place where you find definitions of people of adherence of these religions is for the purposes of personal law. For the purposes of personal law, which governs things like marriage, which covers things like divorce, adoption, and succession, there you have definitions, because obviously each of these communities is governed by a different law. But even then, Hindus, Sikhs, Jains, and Jains and Buddhists are all governed by the Hindu Marriage Act and by the Hindu Code. So there are no clear definitions for these 4 religions either. So this is going to be one difficulty. The second difficulty, but not entirely unsurmountable, is to be able to show when you came to India, which is that specifically prior to the cutoff date. Now this is possible to show for some people, but again requires them to show proof that they have actually come to India before this cutoff date, because keep in mind, if you've come to India and if you meet all the other requirements also, but subsequent to 2015 you won't be allowed inside. So what is the constitutional defect in this law? I'll focus on just a couple of points because there's a lot to discuss, and ideally I think I should leave some time for discussion right at the end where you can raise further questions about the law. Primarily, this law violates the constitutional principle of equality, which is framed within Article 14 of the Constitution, which says everyone shall enjoy equal protection of the law and the law will not discriminate between people. It also, in my view, goes against the basic feature of secularism under our Constitution, which says that the state shall not discriminate between people only on the basis of their religions. Now, what does equality really mean? It doesn't mean that every law applies to everyone exactly in the same manner. It means that the state is allowed to make classifications between people, but it cannot make classifications which A, have nothing to do with the law itself, and B, cannot create classifications where there are no classifications whatsoever. So I like to give this example every time I'm talking about the CAA, which is that if Azim Premji University were to tomorrow put out a call for applications for professors, let's say professors in social sciences, but says only men with red hair may apply. Okay? I hope it doesn't happen though, but still, let's say if it puts out a call saying only men with red hair may apply. Now, obviously there is no real distinction between persons with red hair and persons with black hair, right? I mean, that's a very trivial difference, but there's no real distinction any way possible. So you're trying to create a classification where none exists. The second aspect where this will be problematic is if you say that is the men part of it. Now, obviously, we can agree that at some level there is a difference between men and women, biologically, if nothing else. But does this have anything to do with the actual purpose of the advertisement? Absolutely not. You're looking for somebody who's qualified to teach social sciences in some way. And what does their gender have to do with it? Nothing whatsoever. But it's possible, for example, that it is, say, a women's only college which is looking only for women lecturers and wants to give an opportunity to women lecturers in this subject. So a college in that particular context may be justified in saying only women lecture applicants will be accepted and so on. Not to, and again, hypothetically, not to say that this is an exact situation in law. There is some rational nexus between what the advertisement is trying to do, or rather what the qualifications are required and what the purpose of such an advertisement is. So if we apply this, and I'm very greatly simplifying because I have a little bit of time and I want to take a little bit more on what can make this constitutional. Very simply, that the classifications that the Citizenship Amendment Act creates between people of certain religions and between people on the basis of their country of origin, to me goes directly against the heart of Article 14. It creates classifications where there are none, and these classifications serve no purpose. Now, if the purpose of the law is actually religious persecution, then why are some religions more equal than others? If the purpose of the law is again, religious persecution, why are some countries more equal than the others? Has anybody been able to point out why these three countries are the sole repositories of all religious persecution? Absolutely not. To name just three countries, we have seen that in Bhutan, for instance, Nepali Hindus have been deemed non-citizens and reduced to refugees in India. We have seen, for example, in China, Tibetans not being allowed to practice their religion and being persecuted on that basis. And we have also seen Sri Lankan Tamils and Sri Lankan Muslims, Hindu Tamils and Muslim Tamils who have been persecuted for ground of being non-Buddhist. Now, again, if some have made the argument, but no, you see, these are the three countries which have actually said Islam as a state religion. Sri Lanka declares Buddhism to be a state religion. Not in so many terms, but it places Buddhism above all other religions. Likewise, Bhutan. So this is not an argument that really holds. And we've also seen, for example, in Myanmar, Rohingyas being persecuted on the basis of their ethnic and religious identity. Again, I'm not questioning, and we could question that also, not to say that it's perfectly acceptable. I am taking the government's argument for why this law is needed at its highest. I am saying I will accept that, yes, you want to do this for religious persecution. And I'm putting it subject to the test of, yes, does this law actually provide for some form of redressal for people who are in India because of religious persecution? Well, not some form of redressal, but a pathway to citizenship on the basis of religious persecution. And on the test of the Constitution itself, it fails. Inasmuch constitutionalism is not about telling you, parts of it do, but largely it's not about trying to say what should be the goals of the Indian state and whether you should have this kind of policy or that kind of policy. Of course, there are boundary conditions to that, but it's also about how you get to those policies. Sure, you want to provide a pathway to citizenship for people who cannot go back to their countries. It also matters how you do it. And where this law fails is in the how that it does it, where it discriminates actively based on the religion of the person and on the state of origin of the person. There's also an argument to be made that this law perhaps should not have a cutoff date, fairly valid point. But to me, those are second order concerns. Once you accept that these two things are causing a discrimination, then we try and open it up to see what would be the more pragmatic concerns which might be taken into account. But principally, these are the areas where the law actively discriminates. Is it possible that there is a constitutionally valid version of the Citizenship Amendment Act? Absolutely. If you simply replace the term, if you simply replace the list of religions with any person who has left his or her country of origin on the basis of religious persecution, you could potentially add political persecution also, or perhaps even climate reasons, and is in no position, or rather fears for the threat of their life in that country, they should be given an option to apply for Indian citizenship. Again, keep in mind, nothing automatic about this law. Nobody is saying that immediately the day after, you make this constitutional law, or this law has come into existence, these 31,000 people have nothing to worry about. They still have to apply before the concerned authorities and seek citizenship. There is no guarantee they'll be given citizenship also. So what a constitutional version of this law would allow for a pathway to citizenship that is non-discriminatory. There is one concern that I haven't fully addressed, and that is also something that this law has to take into account. Malvika sort of pointed out very briefly that it tries to exclude regions in the Northeast from its application. Now, this has been done in such a horrible manner that it's possible, as a lawyer, to find 4 mutually contradictory interpretations of the same provision. This is, in a sense, this is clearly a provision which has been put in there out of, the nice term to use it is charity, but the not nice term to use it is contempt. Oh, you people in the Northeast have a problem with this law, here, take this provision. It doesn't actually address the core concern that there might be a large demographic change which might fundamentally affect scheduled tribes, which might fundamentally affect people living in Northeast areas. This is a clause that is so shoddily drafted, and it has been put with such little thought and concern that, again, as I pointed out, there are 4 mutually contradictory interpretations possible, and none of which actually address any of these concerns. It's possible that this provision will also have to be completely ruled out. Again, perhaps not so much from a directly constitutional perspective, although there are people from Assam who have challenged this law on the ground that it goes against the Assam Accords, that it goes against Section 6 capital A of the it's conflicting with Section 6 capital A of the Citizenship Act, and therefore needs to be re-examined. I don't dispute any of that. If this act has to be rethought, right? And those of you who are from Bangalore will know that we had a stage in Bangalore where there were a lot of bedas. We don't want a steel flyover. We don't want this. We don't want that. But now you're finding a lot more bekus, which is we want a suburban railway. We want cycling footpaths. We want all of this. So it's possible to ask for a Citizenship Amendment Act which validly protects the interests of persecuted religious minorities of all of India's neighbors and addresses the concerns of people living in the northeastern states. Because let's keep in mind that we can't wipe away history. There is a complex history to the patterns of migration, to demographic change in the northeast of the country. The Assam Accords were, in a way, an attempt to address this. And it's not as if, everything has to be a one-size-fits-all approach. What that final shape will look like, I can't immediately say, because it is not even clear what the government is trying to do with this provision. The provision which says that the provisions of the Citizenship Amendment Act do not apply to these areas in the Northeast, it's not even clear what it's trying to say. It's possible that there is an attempt at addressing these concerns, but it has to be done in a much more nuanced and a focused manner. So just to summarize very quickly, 3 things. 1, the Citizenship Amendment Act, as it stands, is unconstitutional. It is discriminatory. And the fact that it is discriminatory means it's against Article 14 of the Constitution. The fact that it discriminates on the basis of religion means that it goes against the basic feature of secularism of the Constitution. Second, that it is possible for the CAA to carry out its objectives, assuming its objectives are to protect people who have faced religious persecution in a constitutionally valid manner without denying anybody who's currently being benefited from the law an option to apply for citizenship. 3, the law needs to take into account seriously the concerns of people living in the Northeast, in that it can't just be a clause that is randomly tossed there, that it has to have a serious not a procedure, but a serious mechanism by which the concerns in the Northeast with regard to demographic change are taken into account. In fact, Section 6A of the Citizenship Act, in fact, does this. A clause which is somewhat slightly forgotten is that illegal migrants to India, especially in Assam between 1966 to 71, were deemed citizens of India in the Section 6A of the Citizenship Act, but they were not allowed to vote for a period of 10 years. They became citizens, they had all the rights of citizenship, but they could not vote for a period of 10 years. So our laws allow for such kind of negotiation, compromise, and finding some sort of a mutual ground. but that has to come from an acceptance that we want to do this in a constitutional way as opposed to any which way we feel like. Thank you.
Thank you, Alok. The next speaker is Arun. He needs no introduction. But very briefly, he's a professor of law at the School of Policy and Governance at APU.
Thank you, Vishnu. Can you hear me at the back? Yeah. Very glad to see a good turnout. I suppose we expected this. I should say when Chandan approached all of us, and he can't be here because he's away traveling for an event, the idea very much was that we provide a public forum where people can express their views. So Vishnu started by saying we are in an event, and that's certainly the case, right? So every day you open the papers and you find all kinds of analysis, not just of the questions that Malvika and Alok have spoken about, but how we are responding to what's happening. So I should say that the speakers before me have set up the stage very well. I just want to try and set up the stage so that we can have a good discussion, and I'll try and keep my remarks quite brief. So Malvika referred to a piece of research that I'd done on this a couple of years ago when the issue wasn't as controversial and contested as it is. But citizenship as an issue is not something that has received adequate attention from people in my line of work, which is constitutional law. There's a reason for it, as Malvika explained. The citizenship part is part 2 of our constitution. It precedes the more known part 3 of the constitution, which talks about fundamental rights. But as some of us are looking at these questions and trying to understand that as scholars, as students of the discipline, we are trying to also see how to understand this moment that we are in. So the piece that she talked about was a co-author of that piece. It's been published. It's available online. The lead author is my former colleague at APU, Ashna Ashish. And as Malvika said, what it's part of a comparative citizenship law project. Again, this is a European project. Europeans, as you all know, have been in the midst of a serious debate about immigration, about migration, and as Malvika was saying, these terms have a lot of salience. So do you call it a refugee crisis or do you call it a migrant crisis? A lot turns on that. And sometimes your politics can be revealed by what terms you use. So this European project, it's called Global Cit. They have reports on each European country, but then once they'd done their study of Europe, they decided to reach out to other parts. So we were commissioned to write a report on India's citizenship laws, and it's part of citizenship in Asia. So we ended up writing a paper on how in India, what is the relevant period of history, how do you acquire citizenship, how do you lose citizenship, and what is the legal regime surrounding it. At the end of it, there was an attempt to also say what are the broad lessons that you can take from across Asian countries. And that's interesting. So although we are very much mired in our own domestic debate, which has very specific and particular features, so they need attention and we need to understand them, we also need to recognize that debates about citizenship are going on across the world, right? And we need to have some understanding also of how there seems to be a change. And this xenophobia that we see is explicitly furthered by elected leaders, by presidents, prime ministers, who openly spout the kind of language that we have seen in our discourses. But so the moment that we are in is a larger moment, and there's a larger politics at work, and I think we need to recognize that as well. There's also a larger history that we need to mark and try and understand what's happening in those larger sort of historical projects. So so what I'll try and do is 4 broad points, and I'll touch upon that very quickly. One is the comparative point. How do questions of citizenship look if you go beyond India and say, look at Asia, look at other parts of the world? The second question is the historical question. So both Alok and Malvika have spoken about our history since the the post-independence period. But it would be interesting, I think, to go back to the colonial period as well, and then try and understand why is it that in Part 2 of our Constitution, Articles 5 to 11, look at these questions in that particular way. Right? What were they responding to, and what has happened since, and how do we understand the situation we are in? This is not in the abstract that was circulated to you, but I also want to talk a little bit about the process of what it will mean if this process goes forward, right? And how will this affect every one of us, regardless of our ethnicity or religiosity, and how, if this process continues and we insist on having identification documents, what this will do, particularly not just to Muslims in India, but what it will do to the poor in India. Right? And I think that's an aspect of the citizenship debate which we need to really focus on. Again, that has a much longer history. But this emphasis on documents is going to have a pretty severe effect on a whole range of other things that are part of citizenship. And to use T.H. Marshall's idea of social citizenship, it's not just your civil and political rights, but your right to access welfare measures that are also there, which are really going to be impacted. For most people in this room, perhaps that will not be an impact. We probably all have Aadhaar cards now, thanks to the coercion that was inflicted upon us. But very many of us can get by without really using our Aadhaar cards. And we can still hold on to our principled objection to this coercive policy because we're not recipients of welfare. Right? But if this project goes further and we are asked for more documentation, we need to think of what the implications of that will be. So in addition to the arguments that have been laid out about what does it do to our notions of equality? What does it do to our notions of secular polity? I would also say, what does this do to our notion of social citizenship? And what does it do to the way our welfare policies are also targeted? Right? So on the comparative question, I'll make it very short. As I said, this information is available online if you go to the Global Cit website. It's a very carefully curated website. It does it by region. So if you're interested in saying, how do the Brazilians look at citizenship under Bolsonaro, who was a privileged guest to mark the adoption of our constitution, you can quite easily find those resources. And in an audience primarily of postgraduate students, I think we should also be enabling you to do your own research and find that out. So Olivier Wink, who's the editor of the volume on the Eastern Hemisphere, and it's interesting how, it's called Citizenship in the Eastern Hemisphere, and I was struck by the choice of title, but looking at Asia, he points out three things, and he's a European scholar who looks at citizenship, and he says, how do you look at what's happening in Asia broadly? So he says the first thing that is striking about Asia is that nationality is protected most jealously in Asia. More so than in Europe, more so than in North America, Latin America, or Africa. Right? And his speculation, he offers it as speculation, and it's something that those of us who are thinking about citizenship need to think about. He says this is probably because of the experience of colonialism in Asian countries. Right? So there's a way in which the colonial experience makes you look at the question of nationality in a way which is perhaps different from a Western European. Right? So that's his first point. Secondly, he says, Asia as a continent doesn't seem to have done anything continent-wide about the question of statelessness. And he says this is puzzling because if you have been a colony, statelessness happens quite frequently, right? So whether you're here in South Asia, where we know the background of statelessness caused, of partition and how it causes mass migration. But this is not unique to South Asia. So Southeast Asia has also had colonial boundaries. We know this to be true of Africa. We know this to be true of Latin America. But in Latin America and Africa, there has been a concerted attempt to look at the question of statelessness on a nationwide level. Right? Now, it may well be that in Asia we don't have continent-wide human rights bodies. ASEAN is the only sort of regional body which tries to look at issues across, and that's only restricted to the 11 countries in Southeast Asia. SAARC, we all know, has been a complete failure, and one can't look at SAARC as building a platform for that. But that's something quite interesting to look at. His third point, and I think that fits squarely into what we are talking about, is he says the dominant mode of citizenship in Asia is jus sanguinis. Right? So that this is the idea that you get citizenship by link to descent or blood. Right? And so when I read this, it is striking because, as Malvika and Alok have said, we didn't start out that way. Right? So if you look at the articles in part 2, originally the compact, and this is the broad sort of consensus, is the framers of the Indian Constitution wanted to move towards an enlightened, modern notion of citizenship. Now you might want to think about why they did that, right? So during the colonial period, and one of the things that is often invoked when we talk about the adoption of the Constitution, is the Constitution was important because we moved from subjects to citizens, right? So during the colonial period, we were British subjects, and clearly that was a status different from that of being citizens or of the British Empire. A number of historians have done work on this. Elizabeth Kolsky's work shows us how there was a racial sort of aspect to it in the way the colonial empire saw the native subjects and how it classified them. Again, it was not uniform, right? So within the British Empire, British subjects actually had a higher status. So those of you who followed Gandhi's struggles in South Africa, and the reason why Gandhi is a controversial figure in contemporary South Africa, is his arguments there were very much for Indians in South Africa. And the legal argument he draws on is you can't treat Indians badly because we are British subjects, and something flows from that. But Gandhi did not make that argument for black people in South Africa, and that's why in South Africa there's this question about why is it that an Indian lawyer who comes and basically argues for Indians in South Africa on the notion of British subjecthood should be valorized by the rest of South Africa or the rest of Africa for that matter, right? So in that sense, Gandhi, being a clever lawyer, uses the idea of being subject to argue that people in Natal and Durban have to be given certain privileges, and that's the basis of his claim, right? But nevertheless, when we come to the framing, we realize that the framers say, so we are going to move away from subjecthood, and we'll try and move towards a modern, enlightened idea. And that idea that they hold on to is the idea of jus soli, which means that you get citizenship simply by your connection to territory, right? So if you're born in a place, you have a connection to that. There's some countries which still hold on to this. The United States is a great example. If you're born in the US, you immediately become a US citizen, and that regime is also under threat. We know that Donald Trump has tried to inject a racial element. There's a reason why his political prominence comes by questioning whether Obama was born on US territory or not, right? But at least in the US, in the present moment, the disqualifying factor seems to be not born on the territory of US soil. In India, and I'll refer you to the work of Neerja Jayal, who's worked on this consistently across a period of time. So there's the 2013 book where she talks about social citizenship, and which is really looking at the welfare state aspect that I mentioned earlier. In 2015, she made a contribution to the Oxford Handbook of the Indian Constitution, which looks at the law very carefully, looks at the Supreme Court's rulings very carefully, and talks about this shift. So when Olivier Wong says the dominant mode in Asia today, and he's writing in 2018, is jus sanguinis, that most countries in Asia actually give citizenship by their connection to blood, that is factually correct, right? Because India too moved from a jus soli regime to a jus sanguinis regime. I should say though that this hasn't, and there's a tendency also for us to lionize the framers and present them as these people who were, of course they were trying to bring in a modern enlightened sensibility, but they were also very much creatures of their time, and they were subject to the same passions and prejudices that other people were. So if you look at the debates, and if you look at Articles 6 and 7, for instance, Article 6 talks about people who were forced to leave India and go to Pakistan, or lived in what became Pakistan and were coming to India. For them, the reference, although the text doesn't talk about it, in the Constituent Assembly, people refer to them as refugees. Right? So the idea that they don't have a choice and we have to look after them. So which is very much the language now which is being invoked, although it's not, as we've discussed, expressly talked about. Section 7 talks about people who are Muslims who then leave for Pakistan, and Article 7 quite clearly says they will no longer be citizens of India. There was some debate about what happens if they went and they came back. And in the assembly you find very, very strong language questioning the loyalty of Muslims who've come to India after a certain cutoff date and how that. So what I'm trying to say is that even in the assembly, where you find many enlightened and modern ideas, you also find clear expressions of communal hatred. And we have to remember the assembly, at that time, the Muslim League is not represented in the assembly. There are a few Muslim members who were very much under the thrall of the period and worried about how this would go forward. So in that background, to hear that language would not be very reassuring. Right? So I just want to say that there are elements of jus sanguinis even in the original jus soli model. And it's not a shift only at one point. Again, I just want to mention, if we look at the Assam Accord, and then we look at the 2004 amendments, it's also important to recognize that the Assam Accord, if you look back at it and try and look, it is really puzzling that the Rajiv Gandhi government, which then claimed that it was settling a very important issue, but basically negotiates with a student group, which then goes on to become the Assam Gana Parishad, and puts in place lots of things which are a deep variance with that. So if we have a problem with this, the problems really start in 1985, when the BJP has two members in parliament, right? And that's not everything can be attributed to that. There is something in the original design of our people, and that continues. And I think that's the better way to look at this question. The last aspect, which I think Malvika and Alok haven't spoken about in the CAA, is also this idea of the overseas citizen. Right? This idea of the overseas citizen of India really comes in the 2004 amendment, and that again shows you a jus sanguinis connection, that the 25 million or so diaspora of India, wherever they may be, have a connection to India, right? And they must. Now, this is a very different idea from the idea of the founding, when the idea was that they can apply for citizenship, but they will apply by joining with other people who want to do that. But post-2004, there is this idea that if you are of Indian origin anywhere in the world, that connection of blood allows you to be connected to us. And I think that's deeply problematic as well. And so one of the amendments made in the thing which I think should be called the Atish Tasir amendment is now says that if you're an OCI person, and after all the welcoming of all the NRIs, I think somebody has realized that all NRIs are not only Hindu. Right? There will be Muslim NRIs as well. And there will be people like Atish Tasir who will write and exercise his right to free speech and write a piece in Time magazine which might embarrass our Prime Minister. And therefore, we must find a way to regulate that. So the provision is very, very broadly worded and says if you're in violation of any law in the country, you will lose your OCI status. So it basically means if you're trying to get past Hosa Road and you run a red light, you could lose your citizenship if you're an OCI person. And that's something to sort of think about. So even the BJP's vision of the great Indian nation with across the diaspora is now they're beginning to rethink some of that. Right? And as Alok has also said, there are many untidy aspects of this bill where it doesn't sort of stand to reason. I'll end with the NRC process, and I'll just take a minute, Vishnu, just to say what will it mean if this goes forward, right? So there is a Bangalore-based journalist who gave a talk at BIC and last week in Chennai. She talked about, so Radhika Menon spent 2 years in Assam following the NRC process and then trying to go through what does it mean if you have to go and give documents, right? So it turns out that there are many findings that and I'd suggest that you Google her. She's written in long form. She's also a very effective speaker because she also brings together images that she's collected from her journalistic work. And what she's pointing out to is deeply troubling, right? So if you look at the NRC process, and if we have an NPR, then we know what happened in Assam. 19 lakh people have to now go through these foreigners' tribunals, which I'm convinced are patently unconstitutional. The way these tribunals are constituted, the kind of training people have who are on the tribunals. Radhika Menon interviews some people who've been part of the tribunals and who are quite worried by being in the system of how we are doing this process of documentation. It's also very clear that people who've been in the place for a long time and considered their citizenship to be secure actually never spent that much time trying to get the documents. And they're also very much at stake. So the large number of Hindus who've been caught up in this process, that's clearly an indication that sort of comes up. But of course, also the number of Muslims who are being particularly persecuted in the larger context of Assam and the climate that exists. So the NRC process could well be duplicated in the larger context. And I think that's where each of us needs to think, not out of some solidarity with people in the minority community, but also if we are concerned about the kind of republic we will be and the way we will live up to the commitments of the Constitution, also to some of the weakest sections of our society. Right? So all of us who've been through Aadhaar, and again, if we have to find people to blame, the UADI is really the seed of a lot of our current problems. It's that regime which is being taken forward. And we have to go back to saying, how did we get into this? Right? So as we go for paper documents, there's a lot of scholarly work done by Kamal Siddique's Paper Citizens is a great book which talks about how in developing countries when you're trying to do identification, what are the problems? And these are not new problems. These are 100-year-old problems. Our colleague Tharangani Sriraman's book talking about identification documents, it's published by OUP in 2018, again looks at a much longer span of how do you do it. And those of you who work on welfare rights know Nayanika Mathur's work on Paper Tiger and how do you document Narega or RTI and what's that going to do. So if you now think about citizenship documents and how we are going to have to establish that, those of us in this room will probably be safe. But just think of the implications of that for a range of other people. And then we realize the kind of difficulty that we are going to be in at a time when those resources could really be expended on far more important sort of questions. Right? One last thing to Vishnu's initial point about why is it that we don't have a concern for the suffering of people. Right? So the 31,000 people who are already in the country, and I'm certainly not saying that we shouldn't be concerned about suffering, right? But and we should think of things. So Malvika's point that India is not a signatory to the most important refugee conventions and the refugee protocol is a serious problem, right? And for people who constantly keep talking about Vasudhaiva Kutumbakam, I think it's a bit important that we look at whether we are actually delivering on these great ideals that we preach to others. So what do we do to take in other people, right? So let's look at the numbers. The two largest groups of people in India are more than 100,000 Sri Lankan Tamils, and now between 40 to 50,000 Rohingya Muslims. Right? So we should certainly have compassion, we should certainly care for the suffering of other people, and I'm not going to say you should prioritize by date, but you should find out ways by which we can assist all those who already come to us for refuge. Right? And this is not a plea for saying send those 31,000 people out. There are many, many things that can be done. Malvika's mentioned them. You can give residence permits, you can give work visas. You don't have to provide for voting rights, right? And people can be allowed to work here. And I would suggest to you that 31,000 is for people who constantly accuse other parties of talking about vote banks. We know that the present regime is also looking at vote bank politics. So if the 85% Hindus can be amalgamated into a single bloc, then you can win election after election after election, right? So you only have 31 or 39% now, but you just have to cater to that. You keep it at 40%, you're fine in our electoral-based democracy. So I'll leave you with that, and we'll open it up to questions and answers.
Thanks, Arun. Well, the floor is open.
Sorry, I should mention, and I've been corrected, the journalist I'm talking about is Rohini Menon. Mohan, sorry, I don't know why I'm... so it's not Radhika Menon, it's Rohini Mohan.
Hello, I had a question about detention centers, which is something we've been talking about a lot in the past. So legally, what can essentially, so they're talking about how even with an NRC or without an NRC, we're going to send illegal immigrants to these centers. Even if we ignore the massive human rights violations that can take place at such centers, what is the procedure exactly of sending people back to their countries? Or like legally there doesn't seem to be a lot of clarity on how will you decide whether this illegal migrant is actually from Bangladesh. Will you be able to send them back? Why would Bangladesh accept these people who they will claim are not our citizens? So I just wanted to find out if there's any legal clarity on matters like what do you do with citizens that you deem are illegal migrants, short of simply detaining them for the longest period of time.
Can you just 3 questions and then you answer?
So my question is with regards to some comments made by Jay Sai Prakash. I believe he is a Supreme Court advocate. He released a video on YouTube which was very popular, and in it he makes many legal arguments where he claims that the CAA does not violate the Constitution, and I'm finding it very difficult to have these debates with my friends because I don't have a legal background. So for example, he says it does not violate Article 14. He also says that Ahmadiyas and Shias experience sectarian violence, not religious violence, so it's not a form of religious persecution. So if any of you could elaborate on the arguments he's made and what we can say to counter those arguments.
I just want a clarification on this. Yeah. As per the Assam NRC, we have 19.5 lakh illegal migrants, so-called. While you termed it, MHA says that 31,000 or something is the would be the benefited through CAA. So I'm a bit confused that is this these 19.5 out of these 19.5 illegal migrants, or this is something else?
Let me just very quickly start with the last. Those are actually two mutually different categories. The 19.5 lakh people left out of the NRC are still citizens of India. It's just that now they have to prove before the Foreigners Tribunal that they are not foreigners, and that's literally what they have to do. And only once all their appeals are exhausted will they be deemed non-citizens of India. Now, citizenship is not like a default where if you're not one or the other. If they're not citizens of India, they're rendered stateless. It doesn't mean they automatically become citizens of Bangladesh or anything else, which leads to the question that that young lady asked there. There is a process in law to deport certain people. But what Malvika sort of, and it has been used, it's possible for 1, 2, 3, 4, I think the largest group was about 4 or 5 men from Myanmar, Rohingya men from Myanmar who were deported from India after Myanmar accepted that yes, they're citizens of Myanmar and we will be happy to take them. That, because you can't deport someone without the other country saying yes, we're willing to take them, they're actually from our thing. So as far as I know, en masse deportations, nobody says yes to. Individual cases, it's possible there is a procedure established under law for that. And it involves bureaucratic exchange of a lot of things. It's not the easiest thing in the world. So which is why en masse not happening. But just to answer your question, the 19.5 lakh people, they're still citizens of India. Whereas the 31,000 are a totally different set of people who on paper may still be citizens of the countries which they have left. Now we're giving them an option to become citizens of India. There were other questions about that side. Sectarian and religious is not a category known in law. First of all, in Pakistan, Ahmadiyas are not considered Muslims at all. So in a sense, this is one of the, again, I didn't have time to discuss it, it's a fundamental problem with this law. Do we mean Muslims under definition of Indian law? Or, do we talk about Hindus, Sikhs, etc., under definitions of Indian law or another country's law? There is no clarity about that. And this difference between sect and religion, please find me any scholar who accepts that this distinction is actually real and not something made up to demean smaller religions. So that is the simple answer to that question. The larger point is simply this. Article 14 simply, and this is the most basic test, one of the first cases in the Supreme Court of India in 1951, if I'm not mistaken, pretty much said this is what the test is and nobody has changed it. They've built upon this, they've given it more shades, they've given it more color. It's not, you're not sort of giving like a benefit to someone that you can say wait in queue. If you're giving a benefit to someone, you have to give a benefit to everyone in the same position. You can't, it's fine to say I will prioritize some over the others because they need it more than the others, right? It's fine to say we will, constitutionally it's perfectly fine to say reservations should be for SC, ST, OBC because we have identified that they've suffered historical discrimination. But you can't say within everybody who formerly belong to the quote-unquote untouchable castes, we will give reservations only to 5 and the other castes can wait for another 200 years and then maybe we might give them reservations. That is constitutionally impermissible. So therefore that line of argument is fairly easily rebutted if you actually look at the jurisprudence. And Leah Verghese has written a very long response and rebuttal to his video actually. You might want to check that out. Now, the thing is that detention centers are the alternative to keeping them in jail. And that was a problem. In the sense that the reason why the government even said we should have detention centers is because they didn't want to sort of put them in jail and say, Parapanagrahara here should not be where people who have overstayed their visas should be kept. Now, in as much as one can agree that yes, perhaps they shouldn't be kept in jail, there is a question as to, so then what should be the mechanism? Now, other countries have things like ankle monitors, have mechanisms to say, talk about people who have overstayed their visas or who have not come through legal mechanisms. It's a very large and difficult question to answer, and it isn't as if every person who's an illegal migrant automatically gets sent to a detention center. There is a level of the legal process there, and it has to be a larger conversation as to, okay, so if we say that there shouldn't be detention centers, then what should be the consequence of someone overstaying their visa? What should be the consequence of someone coming to India without passport, or rather having come across the border? And in as much as, and I'll be realistic about this, in as much as it's easy to say here that it's okay, let's be fine about it, there are large parts of this country where they're not fine with it. And not that because they hate immigrants or anything like that, it's just the fact that this does put pressure on local resources, it just does put pressure on local communities, and people would like the government to deal with this.
My question is around the terminology illegal migrants, which is, so do we, I cannot say that if this is a problem or not, like if we at all see illegal migrants as problems, and because of the cutoff date which the Act sets, so is it like giving a larger message that, okay, we encourage migration of that sorts in future, and even keeping this in mind that, okay, they have like some unjustified rationale given around Afghanistan, Pakistan and Bangladesh. So like what happens to the people who are here post 2014? Like even from that religions which they have got in the Act. So what happens around them?
Are there more questions?
My question is about the Assam NRC and the nationwide NRC.
So what NRC?
The NRC happened in Assam and the nationwide NRC.
Yeah, okay.
So the first date in Assam NRC, the cutoff date was not decided by the government. It was decided by the Assam Accord. So now it is very natural that it will be not like 71 or give us 60 years old documents. So, and another is the technological progresses. Like Assam NRC took 7, 8 or 10 years, but that will not take that much time in India. So how, I don't think that it will be that much problematic in India. So I want your comments.
Why haven't we signed the refugee accords? Really, there are 2 accords, I think, there are 2 state, 2 laws, and why hasn't India signed it? I mean, if that, does that have any added value to this? Yeah.
So what happens, like whenever there is a this refugee crisis, like Rohingya, what happens, like people discriminated on the basis of whatever be the reason that they are not provided the citizenship in the Myanmar only, so they move to Bangladesh and India. So whenever there is at international platform, there is always like why India don't have any persecution or a refugee law so that they can accommodate these people who are actually being persecuted, not only basis on the religion, but on the so many grounds like nationality and gender that we talk about. So is it defensible that this law stands somewhere at the international platform to give an extra edge to India that they are having sympathy or empathy toward helping the people on the basis of religion.
So the Ghar Vapsi question I didn't fully understand, because I guess Ghar Vapsi is, as I understood it when it was first articulated, it's an idea of people wanting to come back to the Hindu fold by conversion or reconversion. Right? So I'm not sure how this fits in, but the question to consider is, after the CA rules as they're being drafted, we're getting some information. So there were news stories that they're thinking that they might require people of those communities, the 6 communities, to provide proof of religion. Right? So again, you're thinking of people who've been here a lot and probably escaped with whatever they could get. How will they now establish proof of religion, again through paper documents? Right? So even for the 31,000 people, if it depends on how do they establish that they are eligible for citizenship under the new act. Again, it's going to be a paper trail or a documentary evidence, and how do you sort of get to that? So I don't know. I mean, and unless you're suggesting that there might be now a premium for people who are not from the 6 communities to pretend to be those communities to avail of citizenship, right? And I think that's something to think about. I don't know how it'll pan out. Yeah? But what you're talking about, the larger sort of campaign of saying people are connected to us by blood, that's the narrative of jus sanguinis. And that's why I think the OCI provisions have not got enough attention. But if you also think about how this regime for OCI comes in, right? So India doesn't recognize dual nationality or dual citizenship, but the OCI, the PIO earlier were ways to try and work around that. Right? And these were, they started in the 2003s, and since then they've been there. We also have to think about what does it mean to grant that. Again, this is something that was anticipated even by the framers. And the original time they said these are people of Indian descent, but we encourage them to form ties with their new countries. Otherwise, there will always be, so when the first Pravasiya Bharatiya Divas was held, a member of the Indian community in South Africa came back and objected to this. He said, we have just come here because you're celebrating the diaspora, but please don't create problems for us, because if we go back and then you start giving us things in our home countries now, new homes, our loyalty will be questioned. Right? Or we'll have split loyalty in that way. So there are members within the diaspora who are a little troubled by what this means when you sort of do it in that way. So I think there are questions to think about when we start conferring. And even if one takes a good faith attempt and say, okay, you're coming up with a measure, it might have some implications. You have to think of what might be the consequences of going down that route. Right? So the diaspora who are spread out across multiple countries, a sizable number, how do we recognize their connection to this, a territorial connection, right? So people went to Malaysia, Singapore, to Fiji, to Mauritius, and there is a way in which citizenship laws can recognize a connection. But how do you do it in a way which is mindful of all the considerations involved? I suppose that's the first thing that I'd say. On the question of technology, I don't know if, I'm not as sanguine about Aadhaar, and I don't know if you're being asked all the time, but so there's my PAN card, and there's my Aadhaar card, and then there's a voter ID, there's an election ID, and then constantly we are told you have to align all of them, you have to connect all of them. Even if you look at the UADI presentation in the court, there's a complete denial of the fact that identity theft happens, that technology is not foolproof. There are real concerns with that, right? So I wouldn't be so sure that just because we have better technology, it'll be sort of worked out in that way. So a lot of the scholars I mentioned who try and study how documentation has been done historically, we are also looking at documentation in much more advanced countries which have access to more resources and can work it out. But even in those countries, they're really facing questions because it's the process of identification and tying it to one form which is more valid than the others. There is a bureaucracy involved in our country, which the huge numbers involved, and the huge expenditure that is involved, and who are the people who are going to do it, right? So even if you're thinking about the census, even the way our census is conducted, there are huge problems in that information collection. So I think there are still some concerns to think about, and the Assam process has implications. As you said, it's only one state which did it over a period of time. But all of that got rushed since 2014. It's not, the process really gets jump-started in 2014 and gets over last year. Right? And we saw all these problems not just because the documents are old, but the sheer process of doing it has these many questions involved. Right? I think those concerns, for me at least, are still alive with all my sophisticated ID documents.
Just to add on the point of technology, in Assam they used something called family tree mapping. If I'm getting the name of this thing, software right. And after that, they ended up leaving out 20 lakh. Before all of this, let's keep in mind, Assam was also a state where you had AFSPA. You've also had this concern for more than a generation, in fact 2 generations. The very first NRC was in 1951. So there was at least something to be able to, even if you were born whenever, you could trace to something in the 51 NRC or an election list in 71 and so on. So Assam is actually the place where the NRC probably has worked the best, and you've still left out such a large number of people. I would say, and I say this everywhere, if you actually were to try and replicate, and without changing anything in the Citizenship Act, if you just say, these are the requirements to show citizenship, no cutoff date, nothing, produce documents to show it, 95% of India won't be able to do that. 95% of India will fail to be able to get the or even any modicum of proof that they are actually citizens of India. If you adopt an NRC to say that unless you're on this register, unless you show you were born on this date, unless you show you were here in this date, not happening. So which is why I think Assam NRC is not, if you actually think about it, Assam NRC probably was the way, it only left out 6% of the population. If it were to happen in the rest of the country, it will be the opposite. So which is why I won't use that as an example. I think there was a question on the refugee.
Initially, when the Refugee Convention came into being, I think the thinking was that it catered to a European context, but that's changed. And as of the Refugee Convention, the way it stands now, I think it's just a matter of political conviction, and as that question, the answer to the question in Parliament indicates, it's just a policy decision that India has taken. I don't think there's any real rational response to that.
I think if you look at the lineage of the Refugee Convention and the protocol, I think there was a sense also that we are a poor country and we can't take on from other countries, right? But I think today, when we are projecting to the world that we are prosperous, so 2004, the tsunami, Prime Minister Manmohan Singh said we don't need foreign aid. It's a marker of our development and we've reached a certain point. So India has been positioning, it's also the Security Council seat that we want a table at. I think a much more useful and a much more effective way would be if India started discharging its obligation to the international community by being open and saying that we will take on those obligations that you do if you are really a powerful country that wants to sit at the table, the high table of the world. So then it would mean taking on obligations, would mean sending out UN peacekeeping forces in far greater numbers than we do and taking on obligations in other places. Right? But I think that will run up against certain notions. I mean, the whole rhetoric has always been that we will give privileges to our people, right? And there are no second-class citizens. So in that sense, I don't know how they will work it out. But to me, if you look at it from outside, there's a way in which if you want to project India as a strong country, that you take on more international obligations for that reason. So it's pure speculation on my part, but I'm very struck by the positions we take in other bodies and other fora.
There was another question there about what we look like on the global platform from having done this. But to tie it up to this, even though we're not ratifying parties to the Refugee Convention, we're still bound by the principle of non-refoulement, which is customary international law and therefore binds the global community, so to speak. And if non-refoulement is the only thing that binds us, then the only thing we're required to do is to not deport someone fleeing persecution. What we have gone and done with the CAA is actually meet some very onerous obligations under the Refugee Convention that we did not want to sign up to begin with, which is streamline or rather mainstream an asylum-seeking population into the full rights of citizenship. It's a very high obligation. We chose not to meet under the convention for a reason. And there is still no commitment on our part in this supposed refugee protecting law that we will not deport people who can prove persecution. Instead, what we've done is to say that these people from these communities will be deemed to have been persecuted in their home countries, which is a huge problematic overgeneralization to make in their favor.
For last 45, 50 years, I have been traveling on Indian passport. Now suddenly, because I don't have a birth certificate and I can't find any document which is 75 years old, with the new CAA, what happens to my passport? I want to know that.
Still valid. Yeah, no. It's. You never know. No, because I mean, it's a point that actually Malvika and me were just discussing. You know, those of you who are in Bangalore would have read a spate of reports about Bangladeshi caught in Bangalore airport, Bangladeshi caught in Bangalore airport. One of these cases finally reached court, and you realize that the basis for most of this is a passport officer saying, "Oh, you're born in Bangladesh. You definitely could not have gotten this passport. I'm deeming you have gotten this by fraud." This is somebody who has been openly living in India as somebody who has married an Indian citizen, obtained a passport after all the clearance and after all the checks by all the authorities concerned, right from the local police to the MHA. It's a genuine passport. There's nothing to say, nothing on record which shows it is forged or invalid. The only this thing is, you look like a Bangladeshi, you seem to have been born in Bangladesh, you couldn't have gotten this thing, therefore tossed into jail. So, Karnataka High Court recently granted bail to one lady who, as it turns out, was actually a Christian, and therefore assumed she's protected by CAA, which was an incorrect understanding of the law also, because she hadn't come to India on the basis of the relaxation provided under any particular notification. So the judge, gave her bail for the right, gave her bail as she was entitled to, but for completely the wrong reasons. That's a different point.
One more thing, she only said, I am a Christian.
Yeah.
There's no document produced by her to say that she is a Christian.
It was a self-attestation as far as I was able to say.
As almost most of the legal experts and other lawyers says in the same voice that this Amendment Act is unconstitutional and against the Article 14 and the secularism and all. Why was the Supreme Court not quick to revoke CAA or to at least put a stay on that? And what is the chance? And it has actually postponed the hearing, as far as I could understand, after 4 weeks. What is the chance of revoking this CAA?
This is in relation to what you said a while ago. Considering that if we say that if we include Muslims in the thing and we say it becomes constitutional, but still looking at it with relation to NRC, and you said that they were undocumented masses, how else would a country like India deal with the question of citizenship?
So among the 6 communities which has been mentioned as per the CA 2019, so even Christians are included. So what is the status of Anglo-Indians and what the CA has to offer this community? Because who claims a mixed ancestry from both British and Indians, who majority follows a Christian religion.
On the Supreme Court, a couple of legal answers to what you just said. One is there is a presumption that all laws are constitutional until shown otherwise in court, right? So you make the argument and you show how it fails in court, and then it is struck down, but until it is struck down by the court, it is valid. Just a further point, struck down, I don't think anybody is saying the whole thing should go. As far as I understand it, a lot of the claims are that you should allow, that the law should be read down, which means interpret the law in order to make it constitutional, which effectively in this case means scratch out parts of it and rewrite it to make it valid. Why the court didn't stay it? Now, some laws are, because the thing is that it would mean that even those who are eligible to apply will not be able to apply. It doesn't give anybody else a right to apply. That's the point. When you sort of stay a law, you will have to show why not staying it will cause some irreparable damage to someone immediately. Okay? So in a sense, one possible answer, and the court hasn't said this so much, but it would be difficult to make an argument because the court could very well say, look, even if we agree with you it's unconstitutional, it will only be to the extent of saying others can also apply. All right? So it's just a matter of time when they be allowed to apply. So that is possibly the reason why they didn't stay it. Delay. I have practiced in the Supreme Court for 4.5 years. I have seen cases which have come and gone 10 years with no final resolution. If this case gets resolved, and if this case, a judgment comes in 1 year, I can say that the Supreme Court has done something fantastic in such an important case. Okay, so that's a larger problem with the Supreme Court. There was a second question here. I think you had a question on Oh, how? Undocumented citizens. No, so there are two different things here. For the people who apply to become citizens, you have to show that you're persecuted and so on and so forth. That is not the same thing as to say, you prove that you're a citizen. Why should I? See, there are two separate issues here. Some people who are originally citizens of another country coming to this country to seek citizenship, for them, provisions of the CAA and so on will apply. But the NRC is something totally different. It is asking for people who are already here, who are living here for generations, proof to show that you are so and so. My question is why? It makes sense when you say we are giving this benefit of so and so to a certain number of people. Show us your, there used to be these, I just realized maybe too many people are not young enough or not old enough to know what ration card is. So there used to be ration, for those of us old enough, there used to be ration cards, right? We should go to a ration shop, it should show these are the people entitled to this, you get into show. These are documents across the country. There are various kinds of documents for various purposes. But citizenship is not linked to proving a document. Citizenship is something that's a legal fiction granted to you by the law. You don't have to prove anything. And the question still is, why should you have to? Right? Because we conduct election exercises and nobody says that all the results are invalid because, you know, too many illegal migrants or people who didn't deserve to vote got through. There are mistakes, there are inclusion and exclusion mistakes in any electoral roll as it happens. The Election Commission has been doing a reasonably good job for the last 60, 70 years in preparing these electoral rolls and getting people. It's not as if people have a problem with identifying themselves, but it's a question of for what purpose and does this actually serve a larger governance and welfare purpose. But simply to say, tell me if you're a citizen or not, somehow to me tilts the balance between citizen and state. It is as if the citizen now exists to serve the state rather than the other way around. That is the problem with the whole we shouldn't confuse the two categories. When we say communities, it means adherents of this religion. So there is probably an intersection of Anglo-Indians with these communities. So they will be not seen for their ethnicity. Anglo-Indian, you could probably say is an ethnic category, but these religions are not ethnic categories. So adherents of these religions. Now, how do you show that you're an adherent of some religion? It's not enough to show an Anglo-Indian or otherwise. You have to show you follow one of these religions. How you show that? These rules will probably tell us. And even I don't think even they have any clear idea how to do it. So they will be covered or not covered on the basis of whether they fall within these four criteria that we mentioned.
Yeah, but it's interesting that you mentioned Anglo-Indians, right? So there's an attempt made to take back the reservation of Anglo-Indians in the Constitution. And I don't know what's the logic behind it, right? Maybe as we look at citizenship laws, we look at other attempts. There is an attempt to forge a new identity for us. Right? And that, the 2 seats in Parliament for the Anglo-Indian community was part of a particular historical compact. And this is an undoing of that. So hasn't been done yet, right? It's been notified, yeah. So in that sense, it makes us think also about what does it mean for us as a nation to send signals like that. This is something that was available, we are taking it back. Why are we taking it back now? Does it do something to our plural, diverse character or not? So I think in that sense it's important, but I agree with Alok. I think it's more a religion-based thing. I just want to going back to the first question, and this is what Malvika referred to. Historically, it's important to recognize that the citizenship provisions that we have in Part 2 of the Constitution, which are not part of the fundamental rights, were originally supposed to be part of the fundamental rights. So the Fundamental Rights Subcommittee starts talking about what kind of citizenship we have. Eventually, because of the times and the scale of the migration of partition, the framers decide this is a question which we will not decide now in the Constitution. This is a question that Parliament will decide at some future point. That's Malvika refers to Article 11. And there it says Parliament shall be free to decide this question. I think there's something to think about, and that's an accident of history or compelled by historical factors. But if we had fundamental rights to citizenship, I think then this discourse that, Parliament has decided, therefore nobody can say anything, would have a very different sort of orientation, right? Because we know that all parliamentary laws are subject to violation of fundamental rights. So we are using fundamental rights arguments of equality, of autonomy and other sort of things. But if citizenship was itself a fundamental right, there would have been a different character to it, I imagine, right? So I wonder what the fact that we don't have fundamental rights to citizenship, or for that matter, our right to vote is not a fundamental right. It's a legal right given by another part of the Constitution, but not fundamental. What does it do to the status of this right within our, universe of rights? It's something to think about. And as we think of what else should we do, maybe, as I was saying at the beginning, maybe we all didn't focus on citizenship that much, right? We just thought it's some bureaucratic thing that we do. We really start, so if you teach constitutional law, I suspect most of the lawyers in the room probably never even looked at part 2 very much, right? Just, yeah, it's there, let's just get to part 3. That's where all the action is, the fundamental rights and whatever. But now, thanks to our lived experience, we all know citizenship is terribly important, and we need to pay attention to this. So that's something to think of for the future, I imagine.
Just one very quick point to add. If you haven't already read it, please read Ornit Shani's fantastic How India Became Democratic. The process of how India got universal suffrage, yes, the larger rhetoric is traceable back to 1920. There was always a demand for it. But how it happened in reality was pretty much a bureaucratic exercise which happened in parallel even before the Constituent Assembly had finalized its citizenship provisions, and predates the Citizenship Act by 7-8 years. So it's a fascinating thing, and that book has wonderful insights. So if you haven't already, please read Ornit Shani's How India Became Democratic.
Just to respond to your question about how do we weed out illegal migrants without this proof being demanded of everyone, the Foreigners Act, in I think section 9, places the burden to prove you're not a foreigner on the person who is being alleged to be a foreigner by the Indian government. Typically, Foreigners Act proceedings are when you want to show someone to have illegally migrated to India. So the assumption in law typically, as in this is an unstated rule, but it's also in the Evidence Act, the person who wants to assert a fact must prove it. Okay? So if the Indian government is asserting a fact that somebody is a foreigner, the Indian government is not being asked to prove it, the foreigner is being asked to prove it because they are foreigners, right? So that's a special regime we created saying you anyway don't have that much of a right to this burden of proof rule that lawyers otherwise take for granted, so we've reversed the burden. What's happened now with this illegal migrant and citizen becoming two sides of the same coin, or they're trying to portray it as two sides of the same coin, though we would argue it's not, is that even with the Nrc process, it ends up being that the burden of proving I'm a citizen comes on me, when really if the government wants to say I'm not a citizen, the government should be the one to prove why. Having given me voting IDs, passports, all of these things that are presumptively given only to someone who is a citizen. So to answer how do we weed out illegal migrants, I think it's a different question than saying let's register and check everybody else's citizenship, right? We don't need to do the latter to be doing the former, because the two regimes were distinct, and one regime is much tougher to coast through in a proceeding, which is the Foreigners Act regime. And I think that's the thing we need to separate out. So at the end of the NRC appeal process, if you win an appeal, the rules say that you get on the NRC. The rules don't say what happens if you lose an appeal. And this is the question that somebody on that corner had, which is the rules don't say you will become now detained, right? Because detention is a Foreigners Act invention. But the rules don't also say what happens if you lose your appeal process. So arguably you're stateless, but really can it just be that you couldn't prove that you were born in India in these years to this parent? Because you could have easily been born in India in these years to these parents, but you were unable to prove it, right? So you see the gulf between actually being a citizen and being able to prove a citizen, and how that has very little to do with being an illegal migrant. So the law has collapsed it all in this narrative right now, and I think that's the sticky thing.
So if you look at the responses to CAA, a lot of states has been passing resolutions against CAA. And if you look at, people are going to court against CAA. So there is no response from the government. There is no space for a democratic consensus discussion or anything. So isn't it also a time to deliberate upon the frailties of our constitution, which allows for a tyranny of majority? Because when a single party democracy comes to power, it has unchecked powers on it. And no, even the courts can't, courts are not responding. Even the states passing resolution, you can't bring the government to a consensus. So, isn't it also a time to think about the frailties of our constitution in that sense?
So, do atheists have any place in this? and there is no narrative about the atheists in Bangladesh who are constantly persecuted. So are we as a country not yet ready to have that conversation about people who are non-religious?
My question is on the similar lines. So a report said that 2,000 transgender persons were not included in the list, and there are also protests against CA, NRC, against CA for the entire queer community. So, I mean, how do we read into this situation?
Yeah, also to add to his question about when the Chief Justice of India is not ready to even listen to the petition, and he's saying that until and unless the protest all over India are stopped or students go back to colleges, or everything comes back peacefully to peaceful terms, he's not going to listen to anything. So at such times, or in such times, what should be the societal consensus about this? And the people who are protesting, the students who are on streets right now, does this justify, like, give any justification to whatever they are suffering right now? Just in addition to his question.
Frailty is part of the Constitution. By that logic, we were a single party state till 1975. Till the first, 1977, until the first non-Congress government was in picture. The Constitution was, again, meant to be applied by individuals. And there's this great quote of Ambedkar's that even the best constitutions in the world are going to fail if the wrong people are in power, or inadequate people are in power. It's a frailty of every constitution in the world. There's no inherent reason why putting something down on paper means that it will definitely be followed. And constitutions keep getting made and remade. I'm not just talking about the formal process of amendment. I'm talking about the larger set of principles which animate the constitution, the ways in which it is put into practice and operated. It is not as if in 1950, when we adopted the constitution, we said the way things are today are going to continue forever, except changes in GDP or anything like that. No. The way in which politics takes place, the way in which our institutions are run, the way in which so many different things happen in this much larger conversation, they have been evolving, responding, but within a framework. Right? The Constitution is not code. It is not code to say this is how exactly everything will take place, but a framework in which governance takes place, a framework in which rights are claimed, a framework in which conflicts and disputes are resolved. So that's the way to see it. So we don't just say that just because this hasn't worked out well now, it means that the Constitution is fundamentally failing or in any such way. What we are saying is that we have failed to perhaps use the Constitution in the right way. That may be the answer to your question. There was a question here about the transgender. So this is, again, the protest against the CAA, or actually it's actually a protest against the NRC, because in terms of the fact that given the experience, and in fact, as much as 2,000 women, if I'm not mistaken, have been left out, a large number of the 19.5 lakh people left out are actually women. And we don't know the official numbers yet, but more than 50%, and these have to do with the structural causes that women and likewise transgenders are unable to access the state to claim their rights, to claim their documents and so on. So part of the protest against the NRC is that we are going to suffer this problem on a national scale. And in a sense that this is why it shouldn't be done. There was another question on atheists. This law, I think, assumes if you're born into a certain religion, you're going to stay into that. I don't think this law is particularly concerned with what your actual beliefs are. That's the only way I can make sense of it, because, again, as I said, there's no legal definition, and you will actually not find a legal definition of Hindu, Muslim, Sikh, or whatever across legislations in India, because legislations don't discriminate on the basis of religion. And the only purpose is for personal law, where you're governed by practices which otherwise apply to other Hindus, Sikhs, Christians, and Muslims, and so on. So, which is why there is actually no real way, there's no thought put into, is this a matter of identity? Is it a matter of belief? Is the fact that you were born into a Muslim family and your beliefs changed, is that a ground for, considered a ground that will make it a persecution that you might allow you to take the benefit of the CAA? No thought has been put into that. It is just that we deem you are stuck in the identity that you are born with. That seems to be the approach of the law.
I think it's linked to the frailties of the Constitution question that Richu posed. See, there's been an internal discourse amongst people who study the Constitution, lawyers, political scientists, who will point out all the problems in the Constitution, right? So the idea of the security state, which has always been there, AFSPA, all of so this is known to that small group. And they will point out, even as there's this wonderful literature glorifying the Constitution, people who study it have, over a period of time, documented it in social science analysis, and that's there. I would say that what's interesting is the kind of things that people are trying, right? So there's the 131, there's this in Kerala, Arif Muhammad Khan, and he goes for an aside, and will that be introduced in the actual record of that? So, I mean, to me this is interesting that people are invoking ideas there and procedures in the Constitution, sometimes very technical, to try and pursue that in a certain way, right? So one of the constant debates about the Constitution has been, and this is a very powerful piece by Thomas Blom Hansen, who published in a book called Majoritarian Nation, published in 2019. And Hansen, as you may know, has studied violence in India for over 3 decades, right? And he says, India's democracy, the title of the essay is Democracy Against Law, right? And his idea is, Indians have used democracy, India's deepening of democracy from the 50s all the way to it, has been through violence, has been through use of democratic power to get privileges for certain groups. But it hasn't been through an actual adherence to the rule of law. Many of these things have happened by expressly violating the law, right? So in that sense, I mean, the argument that he makes is the Indian Constitution has never been actually absorbed across sections, even by the elite, who will use it to get things that they want, whether it's the fundamental rights argument or anything else. So in that sense, we are obviously, Vishnu's evocation of the event this is probably an interesting time when it's regular people, ordinary people invoking the Constitution, legislators, governors, everybody getting involved in it, right? And not just the Supreme Court. And as you're suggesting, the Supreme Court seems to be missing from this thing of the law and what is the Constitution, what should mean. But everybody else is claiming, whether it's the citizens, whether it is government officials. So in that sense, to me, as somebody who teaches this and reads this long technical document, it's amazing that there is this popular invocation of it, right? It's, people are saying these kind of invocations are, used to be thought earlier, we were talking about 2011, now people are claiming that since independence you haven't seen this happen, right? So I don't know how to understand it, but I think the fact that there are people also poring over these technicalities is perhaps a good thing to respond to the kind of critique that Hansen makes, right? And maybe if these continue, and ultimately the Supreme Court will also have to decide this 131 question, or whether states can go against the center on questions like this, or pass resolutions. What is the effect of a state assembly passing an anti-CAA resolution, right? All these things will converge. I think there's something happening in federalism. So yesterday the Akali Dal said, include Muslims in the CAA. And it's interesting that it's the Akali Dal, which has been one of the oldest partners in the NDA, but they also took a potshot at the Congress by saying the kind of things that are being said about Muslims is what has been said about Sikhs in the past, right? And there's a certain way of sort of coming. So in that sense, the fact that different people are using different arguments and different fora to make these kind of arguments is, to me, one of the more positive sides of what's happened.
To that, strictly speaking, developments over the last 6 months have really adhered to technical black letter provisions of the Constitution. I'm not speaking to the way in which the government interprets Part 3 rights. That, of course, we all disagree on. But so what happened with Kashmir was a very black letter adherence to the technical, mundane rules while completely eviscerating the spirit of the Constitution. What happened in the lockdown was an imposition of emergency without really imposing emergency. So I think it's also possible to, by virtue of the institutions that were never named in the Constitution, like parties and party units, the state and the center having the same party in power, can determine so much for what kind of constitutional violations can be undertaken without really violating the Constitution on paper. So I hesitate to say that, I mean, of course, every constitution isn't perfect, no constitution is perfect, we're working towards a more perfect union, etc. But I hesitate to say that this is entirely located within the Constitution. Some of it is just...
I imagine we should close now. Really, it was more of a teach-in rather than, regular presentations. Well, thank you very much. Please join me in thanking the panelists here.